Welcome to the Emerging Litigation Podcast. This is Tom Hagy. This is a collaboration, as always, between my company, HB Litigation Conferences, and Law Street Media and Fast Case. And let me just toss in their docket alarm. So in the spirit of the new year, today we're going to talk about getting along, or figuring out how to meet in the middle. You have a dispute, and you decide to take it to a mediator for all of the reasons attorneys already know. Your clients come into the room, often carrying more emotional baggage than a family reunion. They feel they've been lied to, cheated, disrespected. They are a combination of angry, sad, anxious, embarrassed, frightened, and frustrated. Also, they might need a snack, and a nap never killed anyone either. Can anyone possibly help these emotional locomotives meet in the middle without slamming into each other at 100 miles an hour? When it comes to a mediator, you need someone skilled at allowing folks to blow off steam, gently putting on the brakes, not letting anyone feel trapped, and coaxing them into a place where they can gain some sense of control, which is important, and bring the overall temperature down, resulting in, voila, a resolution. And a resolution can mean that both sides are at least only moderately perturbed by the outcome. I'm kidding. We want them happy. We want them happy as anyone can be. This takes a special person, and not to overuse the word, but a special person, someone who's mindful, who can work with them to become perhaps mindful. But I know that word gets tossed around a lot. If you don't like it, we can fight about it, or we can agree to call it. We can call somebody who's thoughtful, a thoughtful person who's aware of all the dynamics that fuel a heated conflict, and how to coax those feelings into something that looks like closure, so everyone can get on with their lives. And isn't that really what we're just trying to do? Why is this important to the audience of this podcast? Because most lawyers negotiate more than they litigate, rather than wrestle with legal problems in the abstract. Many lawyers practice the art of negotiation as applies to their clients and opposing counsel. All the emotions I listed, anxiety, fear. I left out hopeful aspirations. Let's throw that in there. To name a few, these are always present. These are always present in litigated conflict. As a result, attorney negotiators who understand how to negotiate with people who have strong emotions and mindsets have an advantage. There are a lot of people with strong mindsets these days, don't you think? It's also important because some experts estimate that 80 to 90% of all disputes submitted to mediation are actually resolved through the process, which kind of makes sense. You're kind of going in thinking you want to get it over with. I shouldn't say it that way. That's flip. You want to reach a mutually beneficial resolution. It's also important because parties are more likely to comply with negotiated agreements. I guess that might be obvious too. So you can just call me obvious. As opposed to, a court says you have to do this. Believe it or not, some people don't comply with court orders. To answer questions like that, other questions like, what are some of the key cognitive barriers in negotiating in conflict? Got somebody who can answer that kind of thing. His name is Jeff Trueman. He's an experienced full-time mediator arbitrator. He helps parties resolve a whole range of litigated and pre-suit disputes and interpersonal problems. Not that anybody has those here. But he mediates cases involving catastrophic injuries and professional malpractice, wrongful death, and family business dissolutions. You're not disillusioned. Real property, estate, and domestic relations. That's a good time. I was just reading that apparently the divorce rate spiked up at the beginning of the pandemic, when people were trapped in their homes like bees in a jar, and then they kind of reached an all-time low. So you think people are just giving up? Or maybe they're broke. Divorce is expensive. But this isn't about that. This is about Jeff Trueman. He's a panel mediator for the American Arbitration Association and panel arbitrator for the Financial Industry Regulatory Authority, or FINRA. He's a past director of dispute resolution for the Circuit Court for Baltimore County, where he oversaw over 70 retired judges and senior attorneys. Can you imagine that? Conducting more than 1,500 mediations, settlement conferences, and neutral evaluations per year. 1,500 of those a year. This guy has patience. Before that, he maintained his own law office in southeast Baltimore. According to his bio, he was riding the real estate market roller coaster during the 2000s. I remember that roller coaster. Roller coasters make me, I don't know. What's the word? Not sick exactly. Panicky? I don't know. I can't do them. Jeff's articles have appeared in many legal journals, law reviews, magazines, newspapers, etc., newsletters. So he's a distinguished fellow. And that's a real thing. That's not just like somebody with a mustache. He's a distinguished fellow of the International Academy of Mediators, which is an invitation-only membership organization consisting of some of the most successful commercial mediators in the world. And that includes Jeff Trueman. He's a recipient of the Paul A. Dorff Alternative Dispute Resolution Memorial Award by the Bar Association of Baltimore City. This year, he'll finish his LLM at the Strauss Institute for Dispute Resolution at the Pepperdine School of Law. Hey, that's well known for that kind of thing. You can learn more about him at jefftrueman.com. So with that, let's get to it. Here is my interview with mediator, arbitrator extraordinaire, Jeff Trueman. Jeff Trueman, thank you so much for doing this today.
Absolutely. I appreciate the chance to be here, Tom.
Good. So this is an interesting topic. You've spoken on this for me before about the title of the podcast is "Where's Your Head? Managing the Mind in Mediation," yeah. which I like. So you start off, you talk about some of the cognitive barriers in negotiating litigated conflicts, and so some of the things you talk about here are refusal to take responsibility. So what kind of things are you talking about there?
Well, there's a whole host of what we'll call heuristics or mental shortcuts, biases that we're all prone to. Even the best mediators, even the best lawyers who live in this world every day. And, when you're in a really hard fought, hotly contested case, we're going to touch on the hallmarks, the sort of highlighted biases and heuristics. And one of them is it's a cultural manifestation. We see it, there's always someone else to blame for why things didn't go well, or why I got hurt, or why I'm wrongly accused. It can be on both sides of the V, so to speak. Mm-hmm. And people want to have a good opinion and impression of themselves. They don't want to feel that they're to blame for someone else's problems. They want to see that they make good decisions and that they're responsible, they're consistent. And yet the truth is, it's a gray area, as you know, and I'm sure your listeners well know, that this is an area where people can turn words inside out. Factual witness recollections are not always accurate. In fact, there are plenty of studies that show that every time you think of something that happened in the past, it's a different set of events. And the passage of time can make that harder to access in your own mind. So there's a lot of denial that happens just in general and it doesn't even have to be litigated conflict. In general, whenever you're having a spat with a friend, a spouse, a family member, Thanksgiving's coming, so get ready, that kind of thing.
Looking forward to that.
Yeah.
So just kind of set the stage here, though, in the mediation setting. Who are you talking about? Are you talking about the lawyers at the table?
No, for the most part, I'm talking about the parties.
The parties themselves. Okay.
The parties themselves. And in many cases, you may not have a defendant. You may just have their carrier or a risk manager, who operates the hospital or the electric company or whatever it is. And they're not a party to what happened, let's say, but they have the resources to try to resolve it. And, our legal system is limited to really that one remedy in many civil cases. Sure, there are non-economic elements that may make a big difference to someone's life, but in much of the litigated conflict that we see in civil, it's about a number, and you have to try to distill someone's, a loved one's death or the loss of future opportunities in your personal life down to a number, and it's a very difficult challenge. Especially when, and in some cases, let me be clear, there are cases where someone is really not at fault. You're sitting at a red light. All of a sudden, a cement truck rear ends you from behind. You're not at fault for that, clearly. And I'm not going to say to a plaintiff, well, you did get in the car and you realize that getting in the car is risky. And, that's true. We all know that, but you didn't expect to be rear-ended by a cement truck. So you have to kind of take that with a bit of a grain of salt, but realize that people are defensive. And I think that's really, when you sort of boil this down, that's really what I'm saying, is that you have to deal with that natural reaction.
Okay. So when you say you have to deal with, it seems like you're both asking the parties to examine themselves, but I think, and I guess we'll get to this, how the mediator then gets them to examine themselves, right?
Right. Because the culture is such that the people aren't really going to take that time to reflect. They're mad, and understandably so. There may be very sound reasons for someone to react the way that they did because of what a neighbor did, or what a careless driver did, or what a doctor might have done, or some other, I don't know, at a ball game and you didn't get the seat you wanted. It could be anything. Mm-hmm. So you have to expect that people have already lawyered up and found a target of blame, and they're at the settlement table. And there's a whole nother world of sort of cognitive challenges here, where you're telling me on the one hand how confident you are of your trial outcome, but yet you're here sometimes without a court order because you want to be here to explore settlement. So but it's such a different process. People, as I've heard in some circles, sort of litigate, negotiate. What would you say? Negotiate sort of thing, where you're sort of trying to be hard charging, but yet open to a deal. It's tough to do. But right. My point is from the perspective of where I sit as the mediator, you are trying to get people past the past. You want them to think about today and tomorrow. You want them to think about managing this risk, because regardless of how angry they may be, they are facing some risk in going forward with trial.
Right. So again, so some of the theme is, you're saying it is that a lot of what gets in people's way is how they want to be viewed, or how they view themselves, right? Their self-image. That's
right. Their image of the other.
Right.
And again, sort of, you can go pretty deep into the psychology of this, and it's difficult as the mediator who's helicoptering in, has to understand what the legal and factual allegations are, because that's really what the problem has been distilled into by the time I'm consulted, although there's a lot more. And so for me, I want to have a broad understanding, much more than just the law and the facts of what's going on. And I'm not a therapist, I'm not a psychologist, but I have to have some understanding of what's happening cognitively, because in my humble opinion, cases don't settle on the law, and they don't settle on the facts either, because people never agree on the facts. It's even when they can understand and, let's say, accept that the light was red. We understand that and we accept that. The problem is, what does that mean? It means that you had a duty and you violated it, and you took me for granted, or you were texting on the phone, or you were drunk, or you were speeding, or whatever. That's what it means. And you didn't regard me. Mm-hmm. And that's why I'm here. I'm here to make that right. I've lawyered up now, and I want to be paid because you destroyed my life. That's what's really going on, not necessarily the vagaries of some traffic law.
Right. Yeah. It's all about us.
And understandably so. I don't think that's necessarily a bad thing. I mean, we all have to get by in this world, and there's a balance between community and autonomy, and that's not a bad thing.
Yeah, I mean, you say that when people have challenges in their life, and they think, well, I don't want to be selfish. I'm like, well, a lot of times you have to help yourself first. It's like, well, on an airplane, you put the mask on yourself first, right? So, there's a point between there's a balance between putting the mask on yourself first and taking everybody else's masks for you.
Yeah. Well, that's right, and there's a limit to that. I think even with the best intentions, you have to appreciate that you only have so much in resource to give. You really have to take, I mean, caretakers know this. If they don't have time for themselves, they really aren't in the best position to help someone else. And conflict resolution, whether you be the lawyer or the mediator or the risk manager or the claims professional, it is an intense, exhausting profession, and you need to take time for yourself.
Yeah. Yeah. Okay, good. Well, let's kind of the second point. How should attorneys respond? Now, now you're talking about, this is kind of like for attorneys or the mediators, but you're talking about definitely the attorneys who are in the mediation. Is that what you're thinking?
Yeah, I'm talking about, so our discussion can go, there are a lot of attorneys who act as mediators. And so I'm sort of dancing between the two camps with some, some abandon here, wild abandon. But I will say that as a lawyer, and I was in practice for 10 years, and I didn't have as much of an appreciation for all of this, but the ways in which you can manage your client, not by telling him or her that she doesn't have a case, it's by slowing everything down. That's the first thing you can do. You have someone who's really upset. They're bringing to you a problem that may be the most important thing at that time in their life. So help them think it through. And maybe you'll find that the case is even better than you thought. On the other hand, it may uncover warts and problems that you didn't, and that your client may not realize. The trick is to get out of what is called system one thinking and into system two thinking. And system one thinking, you can sort of analogize as your reflexive, immediate, automatic, unconscious mind that will be critical to help you stay safe and to help you get by in the world. You're driving a car. That's automatic at this point. You're talking on the phone. You're thinking of all these things while you're operating a motor vehicle at 70 miles an hour, along with everybody else. Mm-hmm. That's system one thinking. System two
like
thinking,
a reptile, I guess.
Well, you're just reflexive. Mm-hmm. System two, however, is necessary if you're going to fill out a tax form, for example, or you need to think about the elements that would make up a cause of action, or what your defenses are going to be, or how you're going to, let's say, compare homes because you're going to buy a new house. It's a lot of information to digest, a lot of decisions to make. That's system two. That's something you don't want to do quickly. So if you're embarking on a lawsuit, you're defending yourself from a lawsuit, there are so many decisions that need to be made along the way. It's not just a question of whether you will prevail ultimately or not. Mm-hmm. That's a fallacy. You have to be honest with yourself, with your client, with others, family members who are advising you. Look, this isn't just a question of whether I'm going to make it across the finish line and get that jury verdict in my favor. There's all sorts of key moments in the trial that lead up to it. There's all sorts of key moments that can happen afterwards before you even get to an appeal. So you need to really have somebody help you understand, because look, most people don't see how much the legal process has in terms of sideways routes, things that can go wrong with key motions, things that can go wrong with witnesses who don't perform as expected. Sure. And how things can, especially now with COVID still really in the pipeline, how things can drag on and on and on.
Yeah, definitely.
Those things. You got to slow things down as the lawyer managing your client, and all of these heuristics. You want to, creature comforts matter. Yeah. Keep people fed and hydrated, especially when they're making decisions in mediation. Mediation is really about decision making. The challenge is, how do I decide what tomorrow looks like when I'll have no way of knowing how the trial will turn out if I settle this case, and vice versa. If I go to trial, I'll have some sense as to what they offered. They say it's the last number. Maybe that's true. Maybe it's not. But, it's a bunch of unknowns. You're trying to make decisions that have to do with money without having all the information. It's kind of like playing poker.
Right.
And it's difficult. So you need to be awake. You need to be alert and not distracted by feeling hungry or thirsty or whatever.
I'm sensing some mindfulness going on in all of this. Mindfulness and I was going to say mindful mediation. It sounds a lot like meditation, but it sounds like do you meditate?
I'm going to be 100% honest with you that I go through phases where I actually do sit and I do it for maybe 10, 20 minutes at a time.
Yeah.
And then, I think, okay, I'm okay. I'm ground, I kind of, not that I got this, but that I feel like, okay, I'm all right. And then if I fall out of it, and it is mindful. And there's a lot to be said for being mindful as a lawyer and about how you can better counsel your clients and help them make decisions.
Right.
Just as people. Because look, if you live with someone, you've got a family, spouse, pet, look, you're going to come up against conflict. You're a negotiator by virtue of you having other people in your life.
Right.
So there's this balance between how right do I need to be on this issue versus how much do I want to retain and repair and keep this relationship meaningful to me.
Mm-hmm. Yeah.
And, there's a world of conflict that we deal with where there's no relationship between Allstate and the plaintiff who was injured. There's no relationship there. I'm with Geico. It's all, you know what I mean? So like, there's no relationship between the source of the money and the injured party in many cases. Yeah. But there is a relationship with yourself, with the lawyer, with your family and friends who are telling you, what to take and what not to take.
Yeah, I'm just sensing, because I do read and study a lot about Buddhism, and there's a lot of it in what you're saying here is, first, looking, there's a lot of self-reflection going on. There's calming down, taking care of yourself first. That's a big thing with Buddhism. You got to take care of yourself, and then you got to look at things from the perspective of others. But so the other thing is, you say seek to understand, stay curious rather than oppose narratives. Talk about that.
Yeah, to sort of continue on our spiritual analogies here.
Yeah.
It's like the prayer of St. Francis. You should try to understand what's happening with the other side, what they're saying, and what their position is. You don't have to agree, ever. And this is true even outside the courtroom, outside the mediation room. In general, one of the best things you can do for any kind of relationship you have is to let somebody feel heard. It really is powerful. And listen to yourself. If you can try to turn off the automatic judgments, the narratives inside yourself that often reflect like, oh, I'm not worth this, or they're a problem. Instead, what is it about this that's bothering me? What at sort of center, what was really at issue for me? What's the heart of this about? Mm-hmm. What can I do? What can I do today? What have I done before? Has it worked so well? If it hasn't, maybe I need to try something else. Mm-hmm. And that's such a fundamentally difficult thing to do, because it's a transformative orientation that it really requires some time and some effort to stand on a different ground, to look at this problem differently.
Right.
And that can happen in mediation. That's one of the wonderfully powerful things that can happen, but it takes time. And there are plenty of lawyers out there, litigators, who are looking at their watch and wondering why at 12:30 we're still, a chasm apart.
Right.
Yeah.
Yeah.
What are you thinking?
Yeah. And you alluded to, you mentioned this earlier, and it's something that I certainly can relate to, having gone through a mediation over something that I was just bitter about it.
Yeah.
So dealing with anger, you say, understand the stories, embrace the emotions, which is usually anger. How do you deal with anger, hurt, and fear? All of these things that sometimes people bring into the room with them.
Well, they often do, and sometimes it's trumped up because lawyers. It's a naturally adversarial system, and I'm not denigrating it by any means. It's just the system. It is what it is. But anger, as a general rule, is a secondary emotion. It feels primal. It is primal. There's nothing wrong with anger. It's a useful reaction to something. The problem is, and again, going back to Buddhism, you won't be punished for your anger, but you'll be punished by it. And you need to really think about how you manage it.
Right.
Because once you give someone another thing to talk about, this is especially true in interpersonal business dissolutions, family businesses, this kind of thing, you're giving the other side yet another diversionary thing to talk about because you acted like a jerk in the parking lot at this thing, or you embarrassed him or her at this other thing, or you wrote a check and you wrote fraudulently what it was for when you knew, you know what I mean? It's like, it's that kind of stuff that will only dig the hole deeper for you.
Right.
Whereas if you can articulate, look, instead of you're the problem, Tom, I want to share, if it's a good time, I want you to know that I know we've had our problems. I know we've had some issues. I'd like the relationship to be better, and I'm willing to work on it. And I'm going to, stay curious for myself. I mean, not say that curious word, but I might just say that I'm willing to explore what the options are.
Right.
I'd like to talk about how we can maybe, as of today, try something new. Building trust takes time. I understand that. Please know that when you don't answer my emails, I feel like you're ignoring me. I could be wrong. You might be busy, but it triggers in me that sort of, anxiety, because if I'm sending you the email and I put in the body of the email that I need your answer, your response by 5:00 tomorrow, please understand, I'm not trying to take up your time unnecessarily. We're in this business together. We've got to move on this issue. We can work on our relationship, but in the meantime, we've got to manage this.
Yeah,
That's a very different conversation than saying to you, Tom, what the hell? Why aren't you answering my emails again? Right.
How you phrase things means so much. I had a guy say to me once, because I was having a interpersonal relationship, and he said, what works for me is I go to the person and I don't start off with, blasting them. I go in with, help me understand why you didn't respond.
Yeah.
It could be something like
a better way to phrase it, because you're using your own perspective. Help me understand what is going on here. I'm perceiving that you're not answering, or you're not answering me. I don't know. Maybe you didn't have time. There might be a good reason. It's sort of dialing back those assumptions that start to flood you. You're not a good person. You don't give a crap about me. You don't give a crap about this business anymore. It's all that stuff that becomes toxic, and all the cortisol starts going through your body. And it's like, you're really going down. So the thing about anger is to also understand that when there's an accusation, it's really a request. Somebody cares that they're now triggered. It bothers them. It's different if they were indifferent. If there was like zero care in the world, that's not angry. That's probably worse. They don't care. But they're angry and they're triggered. They care. So they may not be articulating it in the best way, but they are asking for something. And you have to kind of, obviously put them into that system 2 brain and get them to calm down before you can unpack what it's really about.
Right.
So understand that anger is second. Anger hides usually a fear, an anxiety, shame, guilt. There's usually deeper, more toxic feelings that are going on. And so when somebody reacts angrily, they're hiding that. So keep that in mind. When somebody's angry, they're asking for something, but you got to de-escalate first before you can really get to that stuff.
Sure. Sometimes anger is the flip side of fear, sadness, or whatever. Sense of loss.
Grief.
So I'm just curious, how do you, as a mediator, when somebody goes into a room and there's just anger from both sides, you've been in those situations. Is there anything?
It's all the time.
All the time.
Well, it is all the time. That's maybe a bit of an exaggeration, but it's often. Most of the time. It's most of the time. I think people who do this have some, healthy skepticism when it's not like that. Like, what's going on? There's something underneath the surface here that I'm unaware of. Otherwise, this would be toxic. And then you feel like almost like, okay, now I understand why. At least it's out there in the open. But when things are really placid and smooth, you got to ask yourself, how you deal with it? You have to there's a combination of factors and techniques. First of all, you want to let the person vent without triggering them, but you still have to let them feel like they've been heard. So you talk in a way that asks open-ended questions, and you try to make it non-judgmental, not necessarily, why did you do this? That's a bad question, because naturally people are going to feel defensive. But what about this situation has you so upset? Help me understand what's going on with you in this scenario.
Right.
How can so-and-so in the other room respond to you in a way that helps you feel heard? Those are different sorts of questions. What's really going on with you? How have you felt in the past? What would you like for yourself going forward? And you have to practice this, because it doesn't come easy, because we're people too as mediators. And sometimes we get triggered. I know I've been triggered when lawyers act certain ways or when clients act certain ways, and it's all I can do to keep my own act together. But you have to try to help them feel heard and that they can trust you, at least with their story and with their information and what they want. And you talk about the practicalities of moving forward and really trying to answer their needs. People really, lay people, thankfully, don't care about legal precedent so much. They don't care about the management, systems of the courts. They don't really care about weeks and weeks of trial. Thank goodness, right? So you have to sort of then think about, okay, what can we do? What can you do to try to move on and move forward? Sometimes people don't want to let go of the conflict. They've defined themselves by it, and that can be challenging. There are high conflict personality types that can be challenging. There are narcissists. There are people with mental health issues. There are bipolar people out there suffering, and it's not easy. You can't just expect to persuade people, right?
Some of the people in my apartment right here are
right. So it's challenging. And I think what tends to happen is because lawyers are, really busy people, they want somebody with status, retired judge, to go in there, tell the other side what's wrong with their case. They'll come round, and then we can finally settle this case for a number that's good for my client. That's the general thinking. Unfortunately, it doesn't really work that way. Not to say that retired judges can't work their magic. Some of them can, and some of them do. But when it's modeled on this idea that the authority figure will just tell the other side what's going on, that's what you think's going on. But if you talk to the retired judge who's actually good at doing mediation, they've got a whole nother gig going on.
The Emerging Litigation Podcast is sponsored in part by Docket Alarm, an industry-leading legal tech and research platform that gives users searchable access to a database of over 500 million legal records. That's a lot of legal records. With Docket Alarm, you can track cases on any device. That's just any device, not your toaster, but any other, we don't have to be specific. Keep up with deadlines and analyze outcomes with pre-built or customized analytics and APIs to give your firm a competitive advantage. You got to worry about those APIs. And now with their latest feature, Enhance. It's called Enhance. That's the latest feature. Docket Alarm will take existing litigation reports and enhance them. Hey, it's named after what it does. It'll enhance them with live links to dockets and complaints, columns on parties, judges, case statuses, or stati, and more. For more information about what Docket Alarm solutions are right for you, or which ones for that matter, visit docketalarm.com. That's docketalarm.com. If you got people really angry, do you put them in a room together, or you keep them in separate because they're going to inflame each other, aren't they? Or
they could. Now, some practitioners will say, let them. Now, under a certain guideline. So it's one thing to say, they're angry and we're just going to put them in a room and see what happens. That's toxic. It could backfire. Yes, there's all of good reasons not to just do that. And there are guidelines that you can put around conversations to have difficult conversations in a way that is structured, in a way that's safe, and in a way where people, remember how we were just talking now about the difference between saying, you're a bad person, you don't care about X, Y, and Z, versus, Tom, I'm having a problem with the lack of response. That type of coaching can make all the difference. And I've tried to do that, sometimes with success, sometimes without success, where you have people who are at each other's throats in the same room. Now, it's not without work ahead of time. You've done caucusing ahead of time. You've set the table, metaphorically, to say, this is how it's going to go.
I gotcha.
And I'm not there to necessarily play judge with my guidelines, because people may not follow my guidelines. But generally speaking, they're not in this situation often. If they trust me, they'll try to use I words more often. They'll try to keep quiet and listen and reflect back. Like when you tell me what's wrong, what's bothering you, Tom, about me, and I say, okay, I'm hearing you say that you don't like it when I don't return your emails. Is that right?
It's hurtful.
Yeah. I'm sorry it was hurtful to you, Tom. I didn't mean it to be hurtful. I just was really busy, or we've had our problems, Tom, and I know we've got other issues to talk about, so I didn't want to answer you. And I'm sorry, I know we've got to manage this. Like, that's a different conversation by at least acknowledging to you, I heard you.
Right.
I didn't respond to your emails. I got that. It's hurtful to you. You're worried about it. I got that. And I'm telling you, I got that.
Yeah.
So now, like, your reason to be angry has been dialed back.
Right. Now, I want to go into my other problems too.
We can talk
I'm just
about
really
that.
generally irritated.
Well, but we're in a better position to talk about it. Right. I may not agree with your being irritated. I may feel that you're complaining and that you're sort of developing a laundry list, and I might have my own hangups about all that stuff.
Right.
But we're not yelling. We're not engaging in violence. We're at least then closer to solving the problem as opposed to the yelling and all that stuff.
Right. This is completely off the track, but it just reminds me when you talk about approaching somebody, how you approach them is like my daughter had to deal with a very difficult young man in a school setting, and he was just really, really aggressive and toward the other I'd say girls, the women. And she was intimidated. And finally, she went to him and said, you really have a hard time talking to girls, don't you? And he's like, yes, I do. And he broke down and he went into all this explanation. And she completely diffused him by trying to see things from his side. I cracked up because I just never seen anything work so well. She couldn't believe it.
Well, and that's an honest moment. He could have responded by saying, no, it's just you or whatever.
Right.
There could have been that response on another day, but he was vulnerable.
Yeah.
And he put it out there. And that's a whole nother key word that doesn't get talked about enough. Vulnerability. I mean, especially when you've lawyered up. I mean, that's what you got the lawyer for, is to protect your vulnerabilities. But when you're talking about interpersonal problems, family businesses, let's say, terrible divorces, employment contexts, even neighbor-to-neighbor disputes, those kinds of disputes really have a vulnerability to them because there's power at issue. And there's a relationship that, let's say, has a history. And maybe they're fighting and one or maybe even both want to continue on. Maybe they don't. But in order to really get to the heart of the matter, somebody has to be, or both of them have to be willing to sort of share that part of themselves that, maybe I shouldn't have relied, but I did because I had hope that we could do this together. Right. That's a vulnerable statement. I had hope that we could. And yet, I'm sorry it didn't happen. Not everything in life happens like that. But what are we going to do about it to manage this thing? The thing about mediation that I try to remind people about is that, it saves time and money. We all know that. We all know what a court could do, not do. I think you're not saying anything to litigators that they don't know already. Mm-hmm. But what you're saying to parties that they may not realize is that, look, you got an opportunity today to retain control over this thing. And that matters.
Today.
Today. Well, today, or if we don't get it done today, the answer is, well, did you settle the case? Well, first of all, it's not mine to settle. Second of all, we're not done yet.
No,
we give us a couple more weeks,
What can we do in the present? Because that's kind of, this also reminds me of Buddhism, keeping the parties focused on the future rather than the past. I guess the Buddhists would be more focused on this moment. But dwelling on the past, it's like, as you said, let's move on and then let's see, how can we make this better going forward?
Well, what's your proposal? Is I like that phrase because it's an open-ended question that allows them to maybe fill in the terms of what works for them. And I may know that those terms are dead in the water, but I might also say, well, let's talk about that. What do you think they're going to do in response to X, Y, and Z? You've heard them say that they deny or that they don't think there's much money there or whatever the issue is. But I just like to say, well, look, we could talk about the past, and you've been doing that for years before you got me involved. What has that accomplished for you? And sometimes you need to keep repeating that. over and over again until they finally get it. And to encourage them to say, look, there is a tomorrow. How are you going to feel, let's say, if we can resolve this? Maybe you'll get some better sleep. Maybe you'll feel a little bit more confident about your business. I mean, I can't really say that, but I want to ask questions so they get to understand that. And then because again, it's critical for people to do the work more so. If I want the deal more than they do, we're not going anywhere, because it's very easy for people to sit back, fold their arms, and then watch me whirl and twirl and just say no to every idea I come up with. That doesn't work. You have to prompt them to do the work.
Yep.
And I think that's where sort of like managing the anger and the anxiety about it, to say, okay, well, you faced adversity before, there will be a tomorrow, just like there was in the stuff that happened before.
Right.
And that tomorrow is up to you, and you can work on that, and you'll have the autonomy. Maybe you'll have resources. You'll certainly be free of all this agita where you can move forward.
Yep.
Maybe that'll be a nice, wonderful, transition out of this.
Right. Look at how things could be if we can get there. You had said this before, but the factual accounts can differ. And I've actually seen cases. Back to your point about how someone views themselves or how they want to be viewed. I swear, some people are able to really believe their facts. not to use the phrase alternative facts, but I think they tell themselves a story. They fill it in with the facts, and then those facts to them are absolutely the truth.
Yeah, they cling to their own narrative.
Right.
And that's a reflection of maybe, a deeper story that they keep telling themselves about who they are, about and this is, a lot of it goes back to how we were raised as kids. What was our relationship like with our siblings or our parents or the other folks who were around us when we were growing up, some of our caretakers. And there's a limit how much you can really get into that. But if you have a chance to talk one-on-one, asking some of those questions can really uncover what's going on with that person. And you're right. I don't have to, let's say, get them off of their narrative or their quote facts. I can agree with that. The question isn't really what happened with the red light or what the doctor did or what the brother did. The question is, what's today and tomorrow look like? What do you want to do? What do you want to see happen? Because, apologies, some mediators think they're overrated. Others, I've had apologies work. Not always, but sometimes. I've had joint sessions when people are super angry, and I give them talk them through how this is how we're going to do this. Lawyers aren't in the room, sometimes with success, sometimes not. You have to be the cheerleader as the mediator. You really have to. And I think as the lawyer too, you're on their sideline, you're rooting for them, you're helping them out, you're coaching them. And as the mediator, I'm impartial, but I'm helping both sides. Instead of it being impartial, I'm sort of omnipartial, where I'm helping both sides try to get what they want. And sometimes that can be a win-win. When it's simply a number, every dollar I take from you, you consider a loss, I consider a win. That's what's called a zero-sum distributive context. That's challenging, but look, both sides have a reason to be there.
It seems like though, because you mentioned an apology, there has to be a difference between some things that are very personal versus complex disputes over mass torts or something where an apology would never, I don't know what that would get you, but how does it differ when you get into something like that, where there are millions of dollars at stake and really it is coming down to money? Or are these emotions at play no matter what kind of case you're dealing with?
Well, there's always emotion. I mean, so when you're talking about a grievous mass tort or some wrong, sex scandals, that kind of thing, you can't imagine a case or a claimant not having emotions over that. It's my father who's died because of mesothelioma, or it was my sister who was assaulted by this perpetrator,
or a young child,
or a child. Right? It's like, how much more terrible could it be? And so, of course, there's going to be feelings around these things. And now we're sort of touching on the limitations of what the litigated court, what I'll say, legal system is about and what it can do and what it can't do. So sure, you can set up, as Ken Feinberg does time and time again, a way in which you can manage hundreds, if not thousands of claims. You usually have, categories, and you've got certain elements that have to be met, let's say. But if you've heard him talk and read some of his books, he will tell you how many times he's engaged in very difficult conversations with the claimants and their family, because they have a story to tell about this experience and they want to share it. It's one of the most sort of important things going on in their life. For years it could be, and they may never be the same because they lost a son or or a mom or what have you, and it may in fact affect them forever. And so that's a deep wound, and yet there will be a tomorrow. I'm not saying it's going to be all roses, but with suffering and this is yet another Buddhism thing, there is suffering.
It's going to be there.
It's going to be there. And many times suffering can create a transformation and can provide meaning. So that it doesn't have to be in vain. In some of the wrongful death cases that I've mediated at times, certainly not in every case, there is a set of non-economic terms that are meaningful to the family that honor the legacy of the deceased. And you put that alongside a number, and the case settles. Mm-hmm. And it's not to say that the number is less necessarily. It's to say that the number in combination with these non-economic elements helped everyone feel that they were respectful, that there was some dignity in that, and that at least now there's a way in which mom's legacy is honored. And it's not every case, and not every institution is willing to do something like that. They want to be done, and they unfortunately they may feel sorry, they may feel terrible, but they're not interested in continuing the relationship with people who sued them. If it's really about a number, because the plaintiff's lawyer has given them very clear indication that it is, let's just find the number, we'll write the check, and we'll be done.
Gotcha.
And unfortunately, that doesn't create any opportunity to heal through the mediation. And I, as the mediator, if that's the way it goes, that's the way it goes. I'm not going to try to force anybody to do stuff that they're not able to do. But let's do that, and I hope both sides find peace.
The last point you have got on our notes is interesting to me. People assess litigated outcomes according to a reference point, and I think you're talking about that now, such as a prior result or a hopeful aspiration. And you say perceptions of a case value can shift. So can you talk more about that?
Well, you have to understand the psychology of how we experience loss and gain. So, and again, this is very relevant when it comes to deciding whether an offer is good enough, whether a demand is good enough, because it happens on both sides. Every time I lose $500, I feel terrible. In fact, I feel worse losing $500 than I feel good getting $500. So my point is that we experience loss more intensely than we do the same amount of gain. Okay. Mm-hmm. Knowing that about who we are, we will then assume more risk to avoid the loss or the perception of the loss. Whereas once we feel like we've gained something, we're more conservative and we'll settle. Mm-hmm. So you have to try to understand where that fulcrum between loss and gain really is. And that's the challenge, because there are people who are good, for whatever reason, at obscuring what that real reference point is. Because, if I know what it is, then I'm likely to manipulate it as the mediator, and they don't want me to know. And oftentimes the carrier, the claims professional, has their level of authority and haven't told their own lawyer what it is, because they're afraid that their lawyer will bargain in such a way to kind of put all of it on the table. And look, if I can save 25 off of my level of authority, I get the promotion. I don't want, you know what I mean? It's just like there's aspirational numbers and there's target numbers. But my point is, in knowing where that reference point is can make the difference between whether someone is willing to take the risk because they perceive loss or not. And I think a great example of this is if you remember the game show Deal or No Deal. I didn't watch it when it was popular, but as I was becoming more familiar with this dynamic, I started to look for the show on YouTube. And it's great because it plays this dynamic out in every show. It's basically that in a nutshell is the whole idea of the show. And what's wonderful about it is that they put other trappings that give it a context and a feel for the real world. We've got a story about who I am. We've got my family and friends that come sometimes even as a surprise. I didn't even know they were going to be there. And instead of putting a number out there, I've got a chance. I told you in my interview, I wanted to buy a new car for my mom. So what do? They put the new car out there with my mom. Like it's such a setup. And then of course there's the nameless, faceless banker, which of course is the insurance company, right? Up at the top, making you a lowball offer to stop playing. I've got an $800,000 case out there and they want me to go away for $50,000. No deal. And the crowd shouts, yay, no deal. Well, that changes over the course of the game. So soon I find myself now in a position where that 800, 750, 500, 300, all those cases are gone. And the best I think I can do is 2, because that's just the way the cookie crumbles, right? Yeah. And now all of a sudden their offer looks pretty good and I'm taking something maybe at around 100 or less.
Is that a dog at your house or?
It's yours.
No, well, that's my dog now.
Yeah.
Okay, that's enough. Okay. Okay. I got an upset English Cocker Spaniel who's ready to. He hears something. Okay, so somebody must be barking outside. Well done, buddy. Well done. Shiloh is.
So in that instance, in that game show, you're seeing someone's reference point change.
Right. Yeah.
Because they're perceiving now, instead of your offer as a loss, it's a gain in light of how the landscape has changed.
Right. I gotcha. What do you think of the expression? It's a good settlement when everybody is miserable.
I hear that all the time. And I kind of let it go and I don't say much because what it does is it at least keeps people's expectations, whether they're really believing and feeling that is another matter, but at least their stated expectations are lower. Yeah. So I don't say anything, but I don't believe it. Right. Because it's not a question. They may not be thrilled having met their aspirational number. Sometimes people do. Sometimes defendants walk away with money in their pocket and I'm aware of it. Sometimes I'm not. Sometimes plaintiffs get more than I know they would have taken. They would have taken less. And sometimes I don't know that. But here's what I know. Everyone is relieved. So it's not a question of being happy or thrilled with the result so much as it is you're relieved that you don't have to prepare for trial. You might have a weekend now with your spouse or your kids as the attorney. You're as the plaintiff, you got a decent number. You know what you're going to get. It's definite. Right. You run the numbers before you've even said yes to it. Yeah. And now it's just a question of waiting 30 days or whatever the timetable is. Yeah. And you're going to start thinking about what tomorrow looks like. Yeah. You've let that go. So, were you thrilled with the result? Probably not. But guess what? In life, you don't get big rewards without big risk. Right. This is what kills me about like all of these predictions, especially in pre-litigated mediations. It's like you're looking for litigated value. You haven't even filed a complaint. Or in the defense, I understand you're looking to pay less, but this is if this does go forward, it's terrible for you. That's why you're here. So you got to pay something meaningful. And so both sides are already off to the races. Yeah. And it's just like, you know what? I realize you're not thrilled with the result, but this is mediation. Yeah. You didn't empower me to make a decision. This is a compromise. I hate to say it, but God knows, right? That's such a dirty word nowadays. This is a compromise to try to be done and manage it. Right. Yeah.
So how do you, take me bridge everything you've been saying. You've obviously thought a great deal about this. I know you have, and I appreciate you sharing it all. So how does this translate to your practice? I mean, do you give this spiel or some version of this? Do you brace people? Yeah.
I try to. I mean, there's a balance between me talking as the authority figure, especially again, when I'm meeting somebody for the first time, perhaps on Zoom.
Right.
And then having me get to know them. There's a balance here. Presumably the lawyers know who I am. I've maybe worked with them or not, and they can see my stuff on the website or whatever. But the bottom line is, I'm here in this case. I'd like to get to know you a little bit better. What makes you tick? What's important to you? What are your values? How do you want to make a decision? What sort of parameters matter? And then we'll talk about, and I'll insert some of these ideas as we go along, sort of to say, look, in making decisions, it's not easy. We all have challenges. And it's not as if I start talking about overconfidence or any of these other things that we touched on today, being angry, it could backfire because people would say, you don't understand. I have a really good reason to be angry, Jeff. And once that sets in, I have lost them. And it's very difficult to reel them back because they know I'm here to try to get them to settle and probably, come off of their demand and challenge them. So I understand that, but I'm also there to try to help them think about the decision from an informed perspective. And, at the end of the day, if they don't want to go under a certain number or above a certain number or not even settle the case, that's fine. It used to bother me because I know our batting average as mediators matters, and they're coming to me to help them get to the printer. On the other hand, I've been doing this long enough to know that I'm not going to lose work just because a case doesn't settle, or even if a few cases don't settle. It happens. It's a timing issue. There have been times when I came in as the second mediator, helped them settle the case. There have been times when I was the first mediator and it didn't settle and they went to somebody else, or they've come back to me. Like, I'm not as anxious about it anymore.
Right.
And so I tell them that this is really, I'm not trying to twist your arm to settle the case. I want you to make the best decision. And I can surely predict or pontificate and prognosticate about what the future looks like. I'm not sure that nobody's going to put it in writing, despite your lawyer's tough talk about all this. So, at some point, I hope you understand how unknowable, especially complex cases can be with so many variables. It's all the more reason why you should think about what it's going to take to settle this case. And I do share the percentages that I say in almost every matter. It's like, look, you don't understand how few trials there really are anymore. I was listening to a district court judge in Maryland. I guess it was a number of months ago. There were, I want to say, like, it was federal court in the particular district. I think there were close to 3,800 cases in just this little civil part of obviously it wasn't criminal or anything else. Only 16 went to trial.
Yeah.
Right. Granted, there were a lot of motions, so it's not like they settled, but they got knocked out on dispositive motions. Okay, that's fine. But that still tells me that there was a ton of settlements. Right.
Yeah. And there are. And any good litigator that I've talked to, and I've talked to many, they said, you don't want to litigate. If you can avoid that, do it. It's not just that it's expensive, because it is. It's just such a distraction and an emotional drain. And it goes on and on and on. So
people can't predict necessarily what's going to happen afterwards. And this is what I try to say. It's like I said earlier, it's not just a question of your final jury verdict. It's about then what? Because look, some defendants, some carriers know they're going to get their heads handed to them at trial. They know that. Okay. But what plaintiff may not appreciate is what happens afterwards. If they don't prevail on a post-trial motion, they have a much better chance on appeal. And they know that. And that's where plaintiff has to worry, because now you still haven't gotten your money. You got a lot more time invested in this case. Now, granted, you might have some interest accruing on your award, but all it takes is for a judge to look at a particular set of questions that counsel raised at trial, or something that the judge did, or something that a juror did, all stuff that's out of your control, and now you're looking at a remand.
Right.
And it's that illusion of control. I'm such a good lawyer. I'm a good person. I'm a good manager of my claims. That's true. I'm not debating that. The question is, can you really think that you'll manage all of the variables going forward? I mean, that's the illusion of control that people labor under.
I think they should teach this in high school.
Yeah, right.
I'm serious.
Yeah.
With my smart mouth, I really could have used some better phrasings. So that's helped me. And I just want to ask, you mentioned judges earlier, and I would think a judge going from, being able to say yes or no and making the decisions, which a mediator does not do, it must be hard for a judge to make that leap.
I think it can be because, yes, they're used to people following their instructions and their directives. Mm-hmm. They're used to having people, sit up and take notice and all that stuff. And that still happens to some extent. I think of it as a guru in a way, where it's just like, if you've already got it in your mind that judge or no judge, your mediator can walk on water, they probably will, because you've already sort of empowered them with that aura of secret sauce. Now, it is a different skill set, but remember, a lot of lawyers are hiring mediators strategically to get a read on the evidence, because it's the evidence that really is going to make this thing sway one way or another. And if it's gray in terms of whether it gets admitted or not, you might want a judge to help you maybe better understand your own case, to go in the other room and tell them why they're going to lose and why they need to pay or come down off their demand. Some risk managers, people who are high up in insurance companies, a really serious case, they need a judge to cover their own rear end because they've got other people to report to. And if the judge disagrees with their reserve, well, at least I've got a judge that told us we under reserved. You know what I mean? As opposed to some mediator, even if the mediator has decades of experience. It's on the one hand, I understand that that's why retired judges are chosen. On the other hand, it doesn't mean that they're good. They have to have a knack for getting along with people. And some judges really haven't had to do that. And they're not really that interested. They'll give you their opinion, but they don't know how to set it up. And they don't settle a lot of cases. Or if they do, and the people feel like their arms being twisted off, it's not a process that they will ever go through again. Sure, I'll settle the case, but I'm not coming back to you. I mean, I can think of judges whose names are fall into that camp. I'm not going to tell you who they are, but they're out there. They're out there.
Yeah, no,
and this is all a word of mouth business. So you're like anything else, like your reputation matters.
Yeah. It was one interesting one when I was in a mediation, and sometimes we could talk about it offline because it was really interesting to me, the process. And it was a judge who was a former judge, but we were in separate rooms, and he was an older guy. I don't know how old he was. He was well into his 70s, and he had to shuttle back and forth between our two offices. I got to tell you, Jeff, one of the reasons I wanted to settle, I didn't want to wear him out. I felt like, oh my God, I can't make him bounce back one more time here.
That caucusing back and forth. I mean, it's funny. I've gotten so many comments. Oh, you're getting your steps in today. Oh, da, 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 da.
Right.
I hear you. And yet that is a norm. Okay. So because the parties need cover, they don't want to bargain in a way that's in front of somebody. Look, if I told you I'll pay you 50 and your demand's at like 200, you told me 200. Well, I offered 50. Now you're going to come off of that number. There's a certain loss of face if you did that in front of me, because you just told me 200, right? Whereas there's an expectation if it's in caucus, I can say that to the mediator. So, okay, I'll come down to 150. Yeah. Well, okay, so we kind of know that there's this dance going on, but when does it actually become real? I'm not taking a number less than 75. Okay, so if they put 74.5 on there, you're not taking it? Chances are you will. That's the same thing in the other room. I'm not paying a dime more than 60. Okay, so if they said 62.5, you wouldn't stretch to, you know what I mean?
Right.
You don't know when you're really done.
But my tip for you in the caucusing and the shuttling is to, if you really want to push things along, just pretend you have a bad hip.
Yeah. Okay.
Ooh,
All right.
okay,
There
I'll
you
take
go.
that back. Well, it worked on me. And here's completely off the wall. If you didn't see it, did you see the HBO Oslo show movie?
No.
Well, I suggest you would get a kick out of it as a mediator, and a lot of what you said. Now, the fact that it deals with the Middle East, they may have gotten all that wrong. So just put that aside. The facts about the Middle East,
Okay.
getting along over there, and Israel and Palestine. But anyway, it was based on a true story about Norwegians diplomats who were seeing the U.S. thing wasn't all going. So they went off book. They went off and did some informal, like behind the scenes negotiating, and they brought together somebody from Israel and Palestine. And I got to tell you, you'll find, talk about making sure they're fed and hydrated. That was a big part of it. A lot of it had to do with alcohol, but also some just really good cuisine, and they made them eat together. And there was so they did a lot of that. They did a lot, and they really stepped out of this is going to be your solution, to the point where the Norwegians took the parties and put them in a room and didn't follow them in. And they all looked at them and said, "Aren't you coming in?" He said, "No, this isn't my you have to come up with a solution," which is very different. I realize you wouldn't necessarily put litigants like in a room like that. But maybe
No, but apparently they did after that whole relationship was on a more supportive ground. It's shrewd. It's brilliant, because they are stoking and forming a relationship.
Right.
Because, I mean, there's a conflict where they are really living together. Mm-hmm. It's not a distributive zero-sum insurance company analogy. It is one where they have a shared future, whether they like it or not. Will it be violent, or will it be, tolerable? That is a basic question that they do have to answer for themselves. But in the way in which you're describing, they set it up, it is brilliant. Think about how many times you can just forget about all of this stuff if we're having a good time. Right. We're having a good time. I mean, it's no more complicated than that. There's plenty of evidence to show that when we're sharing a meal, that there is a lot of warmth and camaraderie that's generated out of that.
Yeah.
So there's a lot of good. And again, and I have colleagues, many of whom are in Southern California, and they'll tell me stories about just terrible, intractable cases where my friend Steve didn't know what else to do. So he took them out to lunch at an Italian restaurant, and they're buying food and they're talking. And so he's literally got them talking and eating about anything other than the case.
Right.
And then they go and they take a look at the facility. Before you know it, they're talking about this and the plans and all this stuff. Again, not talking about the case.
Right.
4 o'clock rolls around. I think we should probably talk about the case. Well, at that point, plaintiff's position changed entirely.
Yeah. Amazing.
It is amazing, because all that time and energy, you would think they were hammering it out. They were banging heads. No. Yeah. They were doing anything other than talking about the issues.
Well, check out Oslo, and then maybe you should write a little piece on what techniques there were, because some of them were yours. And you talk about getting to know each other. It's like you have an Arab and a Jew, and the two of them realize they both have daughters, and both of them have daughters named Maya.
Right.
Suddenly, wait a second, and there was a funny moment where I don't know how possibly this could be true, but the one Arab, he was staring at the guy from Israel, and he was like, "Why are you?" And he said, "You're my first Jew." Now, I have a hard time believing that Palestinians and Israel they've met. I don't know how that came up, but anyway, the point of it being, they didn't see each other as humans.
They dehumanize themselves, and you could say the same thing for the Sunni and the Shia,
right?
And it's and many others, many others, and it's an unfortunate in-group, out-group identity thing. There's a whole other world, Tom, of conflict, identity-based. You've got religion, you've got culture, you might have professions. in-group, out-group is a terrible, unfortunate, race is another one. It's an unfortunate, right? It's just an unfortunate part of who we are.
Yeah.
We identify with folks who are like us, whatever that means. And it's just used too often as a way to exclude and to be terrible to each other. So, but it does require another approach, some of which you can borrow from litigated conflict, but these are relational problems. They're not one-offs. And so I definitely will check this out because you've
Please do.
Curiosity.
Please do. Yeah. The next thing we can do is we'll do something we'll take you in a room and we'll get like Nancy Pelosi and Mitch McConnell and see if Jeff Trueman can bring
I wouldn't blink at the opportunity, but I'm not sure how much hope I would have for it either.
Well, keep an open mind. Stay curious.
See, now maybe you got a future for this game too, Tom.
I would love to see it. Well, Jeff, thank you so much for talking to me about this today. I appreciate it.
Sure. I had a lot of fun. Thanks for the opportunity.
That brings us to the end of another episode of the Emerging Litigation Podcast. You've been listening to my interview with Jeff Trueman, a mediator arbitrator of many decades with a wealth of experience, having overseen thousands and thousands of mediations and arbitrations and other things in his career. And thanks very much to Jeff for taking the time to share his insights with us. If you want to learn more about Jeff, you can go to his website. Everybody's got a website. It's Jeff Trueman, true, as in true versus false, jefftrueman.com, www, you don't have to say that part, jefftrueman.com. This is Tom Hagy with HB Litigation Conferences. This is a collaboration between my company and Law Street Media and Fastcase and Docket Alarm, which is really more of a service than a company. I don't really know what their organizational issues are, conditions, status. That's okay. And hey, do me a favor. Hey, we don't even know each other, and already I'm asking for a favor. If you like the podcast, give us a rating. Go give us a rating. Write a review if you like, if you're feeling up to that. And don't forget, you can also subscribe. And if you want to participate, or if you have ideas for us, write to me at editor@litigationconferences.com. That's editor@litigationconferences.com.